and welcome to this webinar on Charities and the Freedom of Information Act. My name is Rebecca. I'm one of the solicitors in the charity team at Russell-Cooke, and I advise charities on all aspects of governance and commercial matters. I'll include my contact details at the end of the presentation, and if you've got any questions about the content or anything else to do with charity governance, then please feel free to get in touch. Okay, so let's get started. First of all, I'm just going to give a little bit of an introduction to the Freedom of Information Act and its potential application to charities. Throughout the webinar, I will talk about FOIA and the Act, and those are references to the Freedom of Information Act. So essentially, FOIA provides a mechanism for public access to information that's held by public authorities. And public authorities in this context are defined in the Act. There's a list of them in one of the schedules, and it includes things like government departments, councils, the police, the armed forces, kind of organs of the state, and various other types of entity. So public authorities are subject to FOIA in two main ways. The first way is that they are required to proactively publish information relating to their activities via publication schemes. And the second element is freedom of information requests, which most people will have heard of and involve members of the public, or including journalists, making requests to public authorities and receiving information in response. So how does this relate to charities? Well, charities in general are not directly subject to FOIA. So that means they're not usually obliged to respond to freedom of information requests or publish information via schemes. There are some exceptions. So charities that are wholly owned by public authorities are directly subject to the Act. So for example, if a council sets up a charity and wholly owns it, that charity would be subject. Separately, there are a few charities that are named in the schedule to FOIA as comprising public authorities. These are things like the British Museum, for example. However, by and large, the vast majority of charities are not directly subject to the Act. So you might ask, what is the purpose of this webinar? Well, even though they're not directly subject to the Act, charities can be affected by it. And on this slide, I've set out some of the kind of key ways that this might arise. And on the later slides, we'll then go through these issues in a bit more detail. So firstly, if a charity provides information to a public authority, then the public authority will then hold that information, which means that it becomes potentially disclosable under the Act. There are also contracts with public authorities. So in certain circumstances, if you're a charity and you've got a contract with a public authority, information that you generate in relation to that contract potentially could end up being disclosed in response to a freedom of information request received by the authority. The Charity Commission is subject to FOIA. It's a public authority. Obviously, it holds a lot of information on charities. So in theory, and sometimes obviously in practice, information that's held that relates to charities becomes disclosable under the Act. Charities might also receive requests from the public under the Freedom of Information Act, and the question then arises, how do you respond to those? And also there has been talk of extending the FOIA rules to any organisation that is delivering public services, which obviously sometimes includes charities. The Information Commissioner's Office made that recommendation. As of yet, nothing has changed, but watch this space, as in the future it's possible that charities could become directly subject to FOIA in those circumstances. So the first area that I'd like to talk about is receipt of freedom of information requests by charities. So it's not unheard of for charities to receive requests from the public under the Freedom of Information Act requesting certain information. They often look official, they might quote the legislation. So what do you do? So the baseline is that unless you're one of those rare charities that is subject to the Act that I mentioned earlier, generally there is no obligation to provide the information requested under the Freedom of Information Act scheme. That's the baseline. There are some risks here and some nuances, and it's really important to have clear policies and procedures in place in respect of information requests to deal with this situation. So there is some risk that if an official looking request comes in, someone will obtain that, mistakenly believe they're under a legal obligation to provide the information and then disclose it. And obviously that's quite a significant risk, particularly if the information is sensitive. You should also bear in mind that a freedom of information request is obviously not the only type of information request that you might receive as a charity. So one kind of other key example are subject access requests, which are requests from members of the public relating to personal data held relating to them by charities. Those do need to be responded to, and sometimes the terminology used won't necessarily be clear, so you'll need to be able to identify what is this information request and how do we respond to it, if at all. So the key is policies, processes, training. You need to make sure that staff are aware about the different types of information requests, and there's a process in place for dealing with those requests when they come in. Perhaps you'll have a nominated person dealing with them. Perhaps you'll have training for all staff on how to recognise what they are and how to respond to them. But it's important to kind of bear the issue in mind and have appropriate processes in place. The second kind of key area in which charities might brush up against FOIA is in the context of their relationships with public authorities. Obviously, charities regularly have relationships with such authorities, and it's really important to bear in mind how FOIA can impact on them. So FOIA extends to information that is held by public authorities, which at first blush seems a fairly obvious concept, but actually there's a lot it's a bit of a grey area in some situations. So this can encompass the information that belongs to a charity. So and this happens in two main ways. So the first way is where a charity gives information to the public authority, and there are lots of circumstances in which that might arise. So if you are making a grant application to the government, for example, under the COVID funding rules, or you are applying to the big lottery fund, obviously you are going to be submitting information to those entities as part of that application, and that information may then become disclosable should the public authority receive an information request in relation to it. Similar situation would arise in relation to bids or tenders for public services contracts, or any other circumstance in which information is given to a public authority. The second situation is where you have a contractual relationship with a public authority. So say you've entered into a grant agreement, you've entered into a contract. You're obviously going to generate a lot of information in relation to that contract as part of performing it. So that might be things like reports, KPIs, kind of lots and lots of different types of information. And in some circumstances, that information can become disclosable should the authority receive a freedom of information request and ask you to pass it on to them. Because sometimes that information is deemed as being in scope for the purposes of FOIA, because it's deemed to be held by the public authority. And that particularly relates to things that the public authority has a right to see, that relate to it directly, but there is some grey area concerning exactly what it covers and what it doesn't. So before we go on to kind of me giving you some kind of pointers about how to deal with these issues, I should also point out that just because information is potentially disclosable under the Act, it doesn't mean that it always has to be disclosed. There are a lot of exemptions that apply under FOIA, and if an exemption applies, then disclosure can be resisted by the public authority. So I won't go through all of them because there's many. I'll talk about three of the kind of main ones, as it were. So the first one is where disclosure would result in an actionable breach of confidence. So if by disclosing the information, if by the public authority disclosing the information, the charity is actually at risk of someone suing them for breach of confidence, that information does not need to be disclosed. The second main exemption is personal data. So if information comprises personal data, it's not disclosable. And obviously because there's quite serious data protection implications of that. If a document contains personal data, it might be redacted, but it doesn't need to be disclosed publicly under FOIA. The final exemption I'm going to talk about is where disclosure is prejudicial to commercial interests. And this has to be a kind of genuine prejudice. It's kind of usually of potential more application where it's a relationship between a commercial organisation and the public authority, but sometimes it can apply to charities, for example, in relation to bids for public services contracts. So, how should you approach your relationships with public authorities in the context of FOIA? So the first point is just to understand the risks at the outset. Know that information that you give to them, information that you generate in relation to that relationship, it could be publicly disclosable. So be aware of that. Second point to know, check the agreement that you have with them. So a lot of the time, or pretty much all the time, agreements with public authorities will have Freedom of Information Act provisions. They will normally just acknowledge that the authority is subject to the Act and have various requirements in relation to what the charity needs to do should the authority receive an information request, so passing over information, and then also a requirement for the charity to pass on any information request that they receive to the authority. Check the terms carefully. If there is an extremely wide provision saying we're subject to the Freedom of Information Act, you have to give us any information we ask for in the event that we receive a request, that's incredibly wide. You don't need to give them all the information that they might want. So that's the type of provision that you might want to resist. For example, can you introduce categories, what's disclosable, what's non-disclosable, so everyone knows what they're doing? Or can you kind of pare it back a little bit so it's clear that only disclosable information is going across? The final point is just internal information management, and that's really important. So when you're in a relationship with a public authority, make sure you've got a good system for managing the information that's generated in relation to that relationship and storing it. Think about, what's disclosable, what isn't, where should we store this? How should we kind of record what we're doing? Spreadsheets, folders, things like that. It doesn't have to be massively complicated, although in some cases it might need to be. But it's just really important to bear it in mind and make sure you've got good record keeping processes. When you're going to send information to the authority, only send them what's necessary. Bear in mind that it might become disclosable, and think about, do you actually need to give this to them? If you do, it's worth also thinking about whether you think a FOIA exemption could apply. So is there personal data? Is this genuinely really confidential? If so, flag it when you send the information. Doesn't necessarily mean it will definitely not be disclosed, but at least you've made the kind of point and you can discuss it further if needed. So the last topic that I want to cover is the Charity Commission. So as a public authority, the Charity Commission is subject to FOIA. Obviously, the Charity Commission has a huge amount of information about charities in its records, and it does receive requests from members of the public and journalists concerning charities, and that information that it has could well be disclosable. So, for example, it's got governing documents, it's got serious incident reports, and it's got inquiry kind of reports, and a huge amount of information in there. Now, obviously, as a charity, you might give the Charity Commission information that is quite sensitive. So it's important to bear in mind that when you're doing that, at some point that might end up being disclosable. So what's my advice? So essentially, again, I would recommend only submitting necessary information. Only give the information that you actually need to give. If you're doing a serious incident report and you need to do it, obviously submit it, but you don't necessarily have to include the entire backstory. You just stick to the facts, stick to what you need to disclose, and give them that information only. If you think, okay, we need to disclose this, but you think maybe an exemption applies, again, flag it. Flag where information is truly confidential, flag where it contains personal data, and communicate with the Charity Commission about that. And the final point, avoid submitting personal data where possible. The guidance on serious incident reporting says don't include personal data if you can avoid it. And so if you're talking about an incident that's happened with a trustee, don't name them, just say a trustee. The Commission needs the information, they will get in touch, and you can give it to them at that point. Okay, so that concludes my webinar about charities and freedom of information. I've put up my contact details on the screen now. Be delighted to hear from you with any questions. Hope that was helpful and hope you have a great rest of your day. Thanks very much for listening.